Welcome to the training module on Statutory Declarations, Part 1. This training module provides the Justice of the Peace with the knowledge needed to witness a statutory declaration. When a person makes a statutory declaration, they are declaring that the statements in it are true. If they intentionally make a false statement in a declaration, they can be charged with an offence. The penalty for making a false statement in a statutory declaration is a maximum of 4 years imprisonment. Declarations made under different acts may have different penalties. Statutory declarations can come in many variants. Each state and territory and the Commonwealth have their own format. A statutory declaration can also be embedded in an application form. The key things to look for is a title that says Statutory Declaration and a reference to the Act under which the statutory declaration is made. If there is no reference to the Act, then it is not a statutory declaration. A statutory declaration is a written statement of fact in which a person formally declares before an authorised person that the statements are true. A statutory declaration can be made in the form prescribed by Section 25 of the Oaths Act 1936 when it is required for a purpose under South Australian law, or the schedule to the Statutory Declarations Act 1959 when it is required under Commonwealth law. The link shown on this page provides useful information for authorised witnesses. The persons who can witness statutory declarations are defined by the legislation for that statutory declaration. Commonwealth statutory declarations can be used in connection with the administration of any department of the Commonwealth for the purposes of a Commonwealth law, in connection with any matter arising under a law of the Commonwealth, or for the purposes of a law, or in connection with any matter arising under a law of the Australian Antarctic Territory, Australian Capital Territory, Coral Sea Islands Territory, Norfolk Island, Territory of Ashmore and Cartier Islands, Territory of Christmas Island, Territory of Heard and McDonald Islands, and Territory of Cocos or Keeling Island. The Justice of the Peace Act 2005 allows for a South Australian JP to witness documents when outside South Australia if the document is for use in South Australia, unless the Act under which the document is made provides that it must be done in South Australia. If you are not in South Australia and the document is for use outside of South Australia, you have no authority to witness. South Australian JPs may witness a Commonwealth statutory declaration anywhere in Australia. You can prepare your own statutory declaration form which differs from the standard form. However, you should get legal advice to ensure the resulting declaration is valid. Commonwealth statutory declarations can be found on the internet at www.ag.gov.au. South Australian stat decks can be found on the internet at www.agd.sa.gov.au. Downloadable copies of statutory declarations may be found on the website of the organisations requesting these. These are referred to as end-user portals. It is not the authorised witness's responsibility to provide forms for statutory declarations. However, it doesn't hurt to have a few blank forms in your bag. If a client requires a statutory declaration form for a different state or territory, then it is their responsibility to acquire the correct form. Having copies of a few blank South Australian or Commonwealth statutory declarations in your bag is a good way of providing excellent service to clients. Every state and territory has their own statutory declaration. The format of each of these differ in subtle ways. Regardless of variations in format, they all have a heading called Statutory Declaration, a section for the person's name and address, their statement, a reference to the Act, and a jurat. A South Australian statutory declaration can be identified because it will contain a reference to the Oaths Act 1936. Be aware that some statutory declarations come under acts other than the Oaths Act of 1936 and consequently carry different penalties. For example, the Department of Transport taxi licence renewal statutory declarations carries a maximum penalty of $15,000. Statutory declarations from other states and territories can be identified because they will contain a reference to the relevant legislation from that state or territory. Statutory declarations always follow a specific structure regardless from which jurisdiction they originate. It will have a heading that says Statutory Declaration. This is followed by a section where the declarant enters their name and address, then their statement of fact, followed by specific wording and specifying the act under which the declaration is made. For example, and I make this solemn declaration conscientiously believing the same to be true and by virtue of the provisions of the Oaths Act 1936. The statement of fact may be a narrative, or it may be a form with tick boxes, or it could be either or text to cross out. It could be a combination of all of these. The final section will be the jurat. This specifies the place, date, signature of declarant, and the witness signature, ID number, and authority. It doesn't matter how a statutory declaration is packaged. Often a statutory declaration will be incorporated into an application form or a form specifically designed for a single purpose and may not look like the general purpose statutory declaration form. It may be completely handwritten, and if this is the case, check it contains the appropriate wording. It may be presented to you crumpled, partly torn, or looking like the dog ate it. If it is legible and sanitary, then proceed. Remember what the key things are to look for. Heading that says Statutory Declaration, completed statement of fact, reference to the applicable act. When you see these, you know you are dealing with a statutory declaration. If a statutory declaration is presented to you that is part of a form, then invariably it will contain specific instructions to the witness. You must look for these. It is also common to get declarations as opposed to statutory declarations. These make no reference to an act and usually just say declaration. When faced with these, it is recommended that you follow this statutory declaration procedure but write the following statement next to your signature. Signature only, witnessed. Modifying a completed statutory declaration. There are two options available if a declarant wishes to make a modification to their statement in a completed statutory declaration. You can complete a new statutory declaration or modify and redeclare the existing statutory declaration. The choice is theirs to make. If the changes are extensive, it's probably a good idea to complete a new statutory declaration. In either case, the entire process must be repeated. If the statutory declaration is amended, then the alterations must be initialed and a new jurat added. Do not alter or cross out the existing jurat. This concludes the session on Statutory Declarations, Part 1.